for the one pleading. Participants cannot use any sort of unparliamentary words and are requested to maintain the decorum of the court. Participants are allowed to communicate with their teammates after seeking permission from the judges during the rounds. Speaker is not allowed to discuss subjects with their researcher, but researcher is allowed to pass chits to the speaker after seeking permission from the court officers. The structure of the competition is as follows. There will be 3 stages in this competition: applicant pleadings, respondent pleadings, rebuttals, and surrebuttals. Each team shall have maximum of 30 minutes, of which 15 minutes is the maximum time allotted for each speaker. This includes the rebuttal and surrebuttals. At any point of time, the judges may seek clarification from the teams and also question them on any part of the arguments presented by the participants. However, the time will not be stopped during such process. If the team exceeds the time allocated, there will be negative marking. Now we shall start the round after taking permission from the judges.
Permission granted. Granted, please go ahead.
Greetings to the Honorable Bench. In the case of the Democratic Reforms Project and others versus the state of Bharat Nadu, the council represent the petitioner, that is the Democratic Reform Projects and others. The council would request the Honorable Judges to refer to them as Your Honours. Much obliged, Your Honours. Are the Your Honours well versed with the facts of the case? And
Yes.
the council would like to proceed to the issues.
You can proceed.
Much obliged, Your Honour. The council would be dealing with issue 1 and 4, while my co-counsel would be dealing with the issue 2 and 3. Issue 1. Does the use of an AI algorithm in pre-trial detention, bail hearing, and sentencing violate the right to free trial guaranteed under Article 21 of the Constitution of Bharat Nadu? It is humbly contended that the AI algorithm violates Article 21 and its principle of free and fair trial. Free and fair trial under Article 21 is the heart of the criminal jurisprudence and is an important and indispensable element of free and fair trial as guaranteed under Article 21 of the Constitution of Bharat Nadu. To support my arguments, the council would like to refer to 2 cases. The first case would be K. Anvajangan versus Superintendent of Police. The council would request the judges to refer to flag number 1 and the highlighted part. Much obliged, Your Honour. It was held in this case that free and fair trial is sine qua non of Article 21 of the Constitution of India. If a criminal trial is not free and fair and not free from judicial bias, judicial fairness and criminal justice system would be at stake and shaking the confidence of the public of a state. The council would also like to refer to the case of Ratiram and others versus the state of Madhya Pradesh. Flag number 10.
Counsel, let us know, when does the trial begin?
Your Honor, the trial begins when the charge sheet is being submitted to the magistrate and the judicial inquiry is being done. Then the trial begins with the statement of facts.
All right. Then how do you say that the pre-trial detention decision and bail hearings would come in the way of a right to fair trial?
Pardon, Your Honor?
Now, your submission is the pre-trial detention decision and the bail hearings are coming in the way of the fair trial that is guaranteed. If the trial is something, as you said, commencing after the filing of the charge sheet, and these things does happen prior to it, how is it the trial being affected in
Your Honor, investigation in the state of Bharatnadu happens in three ways, and that in among the trial, the bail hearing is an important factor to provide justice. The end goal of a trial is to provide justice and to maintain confidence in the eyes of public and confidence in the system.
Right, let us know this, whether the orders which are passed on the bail petition have got any bearing when the final adjudication takes place and the judgment is rendered.
Pardon, my lord?
Now let us know if at all the orders which are passed on the bail petitions or the orders which are passed on the pre-detention petitions, do they have any bearing on the final adjudication of the matter?
Your Honor, they do not have any final adjudication in the matter. However, they act as an important logic and an important factor in the judgment, and it is a part of the trial to set the convict free.
Now we'll clarify once again that any orders that would be passed at the pre-trial stage shall in any way not influence the final outcome of the case. Would it solve the issue?
Pardon, Your Honor?
Like the clarification is given by this bench that the orders which are passed on the bail petitions and the preventive detention petitions will not come in the way of the consent courts exercising their jurisdiction and adjudicating the matter uninfluenced by the said orders. Would it solve the problem of your grievance regarding a fair trial?
Your Honor, the counsel would beg to differ that the bail hearings are being violated, and it is the part of the trial. It is under the due process of law that trials are being there, and bail hearings, pre-trial detention, and sentencing is a very important and major element of trials.
Very well. When does the sentencing stage arise?
So after the statement of charge,
Are you sure?
charges. So the counsel would beg apologies for the little knowledge it has, and it may be wrong. However, due to the little knowledge the counsel have, it happens after that.
Very well. Please.
Yes, Your Honor. Your Honor, hence in the case of Rattiram, it was said that it would not be an exaggeration if stated that a free trial is the heart of criminal jurisprudence, and in a way an impartial facet of a democratic polity that is governed
We
by...
are aware of the proposition of law.
Yes,
Kindly
Your Honor.
advance the submission.
Yes, Your Honor. Your Honor, hence the AI algorithm comes in way with the free trial detention, and it violates and breaks the heart of the criminal jurisprudence as mentioned in the Rattiram case. It also comes as violatory under a free and fair trial under Article 21 of the Indian Constitution as mentioned by K. Anvan.
When it comes to AI algorithm, so how can you have this befitting reply out there, because there is someone who has made it, number one. Number two, when it comes to the nuances which are coming out of it, definitely they are to be believed in some way or the other. But how can you say this, that the algorithmic kind of stuff which is coming out of such submissions may create some troubles, ultimately in providing the justice?
Yes, yes, Your Honor. Your Honor, the data which has been provided by the... Yes, Your Honor. The data which has been provided by the AI algorithm is an objective scientific data based on generations of prior convictions. Whenever a case has been heard, it is updated again. And if there is any violation, any problem by the AI algorithm which is unable to be addressed, it will lead to more problems. It will lead to violation of Article 21 and the doctrine of free and fair trial. And thank you, My Honor. My Honor, the counsel would request to move to issue 4. Much obliged, Your Honor. Issue 4. Does the use of an AI algorithm to predict criminal behavior violate the right to privacy guaranteed under Article 21 of the Constitution of Bharatnadu? It is humbly contended that the AI algorithm do violate in all ways the doctrine of right to privacy as guaranteed under Article 21 of the Constitution of Bharatnadu, and while this algorithm was made, the Constitution was not respected.
Is there any latest case law which has been decided by this honorable court which supports this very important point which you are making?
Yes, my Honor. Yes, Your Honor. Your Honor, the NAS Foundation case, which is the NAS Foundation versus the Government of NCT New Delhi, was a case of 2017. It is the latest case. Also, under the Menka Gandhi versus the Union of India case, there was a triple test been declared by the government, and another triple test is been introduced in the KS Puthuswamy versus Union of India case. And the AI algorithm failed both the triple tests.
But when it comes to the regulatory regime with respect to AI, I do not think there is a passive protocol which is there in place, which basically helps us understand as to which way AI should go and how it's to be used for various purposes. So what is your take on this?
Pardon, Your Honor?
When it comes to regulate this AI regime, because AI cannot be seen as a singular. AI is a plural stuff. So in that sense, do we have some kind of regulatory regime also in place at present, which basically helps us understand the biases which we may otherwise find while using it?
Your Honor, the state of Bharat Nadu has passed a procedure for the said AI. However, they refuse to publicly available and make the AI algorithm transparent to the public. Yes, Your Honor. Your Honor, in the case of Khadak Singh versus the state of Uttar Pradesh,
Counsel, at one juncture you say that the right to privacy is being infringed, and on the
Yes,
other
ma'am.
hand you say that it is not disclosed. Now, how do you go ahead with these kind of a contradictory submissions that you are making?
Your Honor, the counsel was.
Disclosure or the privacy rights to be kept intact? Either of them.
Your Honor, the counsel was referring to the disclosure of the AI algorithms basis on how justice has been provided and the basis on which criminal behavior, educational background, neighborhood, community, digital communication is been set. The right to transparency is been asked by the counsel, and the right to privacy under Article 21 has been infringed.
Please. Para 15 of the fact sheet.
Yes, Your Honor.
Para 15 of the fact sheet.
Yeah, Your Honor, may the counsel please take from the researcher. Thank you, Your Honor.
Well, in all fairness, you should have had a copy of it. Facts is the heart of the submission.
My humble apologies, Your Honor. I actually had the copy, however, I forgot it on the table. Yes, Your Honor, Article 15, point 15 of the moot proposition. Yoga Drishti has been statistically proven to be more accurate in predicting radicalism than traditional methods used by judges. Yes, Your Honor. However, Your Honor, if we move to the Annexure articles under Article 1 and Article 2, it has been also said that there have been instances where the AI algorithm has not been correct. In Article 1, the AI algorithm just predicted that Mr. Kumar, who had no previous convictions, no previous history and educational background, was convicted due to his community because he hailed from a poor family. Such instances are been recorded and updated in the AI algorithm, which intends raise questions about whether the AI algorithm is efficient, credible or not. Is it impartial or not?
Counsel, but this petition doesn't arise out of any orders passed in the said case. Now, we need to look into this in an independent way. Those orders have never been challenged before, to go into it.
Your Honor, the moot proposition stays silent whether the orders have been against. However, it was an instance in both in which it was happened, and in Article 2, the judge disapproved with the AI algorithm. Also, in point 18 of the moot proposition, on the last line, it is said that the law maintains that the judge has the final say and must explain why they disagree with the AI's recommendation. However, it is not mentioned that when the judge agrees with the AI algorithm, why should he not? Why the honorable judge should not present with a recommendation or argument,
Well,
which
an
is.
agreement doesn't require a reason. Only a disagreement warrants a reasoning to be given. Isn't it, sir?
Yes.
Yes, Your Honor, the counsel would beg to differ. However, if the AI algorithm is setting an agreement, the judge too should have, the honorable judge should also have a say in how, because it is a scientific and an objective data which is based on previous past generations of records, and it is updated and it is being updated many times. It is a very recent AI algorithm which needs to be updated and seen, which is it has been not. The council would request to continue with issue 4. Thank you, Your Honor. Your Honor, under issue 4, under the case of Khadak Singh, it was said that right to privacy, personal liberty takes not only a right in free from restrictions but also free from private encroachments. The AI algorithm takes away these private encroachments. Under point 12 of the moot proposition, the data which has been there is violative to the private. The council would request another minute. Thank you, Your Honor.
Greetings to the honorable bench. This is counsel 2 appearing on the side of petitioners, that is the Democratic Reform Project and others. The council would like to seek permission to address the benches, Your Honors. Much obliged, Your Honors. Issue 2, whether the use of an AI algorithm to predict criminal behavior violates the right to equality guaranteed under Article 14 of the Constitution of Bharat Nadu, disproportionately affecting certain communities, Your Honors. It is humbly contended, Your Honors, that the use of AI algorithm to predict such criminal behavior does violate right to equality guaranteed under the Constitution of Bharat Nadu by disproportionately affecting certain communities. Your Honors, the argument would be advanced in a threefold manner by the council, by first proving that it is the clear violation of the Article 14 of the Constitution of Bharat Nadu, then that the classification it makes is not based on intelligible differentia, and further that it affects the independent discretion of the judiciary, Your Honors. The council requests the permission to proceed with the issue. Much obliged, Your Honors. To begin with, Your Honors, the council would like to quote the bare language of Article 14. Equality before law. The state shall not deny to any person equality before law or the equal protection of laws within the territory of Bharat Nadu, Your Honors. Your Honors, Article 14 is a safeguard of equality for every individual. But when certain software such as this AI are put into use, it amounts to huge threat to the right to equality, because the mere basis of this AI is to classify people into different risk brackets and categories, which clearly violates the equal level that they should be kept in the first place, Your Honors.
See, the issue is very simple in understanding. As you are saying, like when it comes to the research to be made, or when it comes to the data to be collected, definitely there will be some pointers in terms of, let's say, scaling. You will do the scaling, and you will have people in place there. So definitely when the data is going to come out, there will be authenticity to some extent into it, isn't it? So you will have some kind of, you can say, outcome which could be believed in some way or the other. So what is your take on this, as you are making a point out there that when the data is being conceived, so definitely something would have been given as an input, right?
Yes, Your Honors.
And accordingly data is going to come out of it. So when the data is going to come out of it, some kind of outcome will be there. That is what we have today also. When it comes to the things which are happening in air, we have so many platforms, and we do believe that data to some extent. Understood, and all is also there.
Yes, Your Honors, the council understands the concerns of the bench. However, the council would like to take the stance that the kind of input that is put into the AI algorithm would decide the output that would come out of it, Your Honors. The input is based on, as my co-counsel pointed out, is based on history of generations, Your Honors, and our history comes with the societal biases included in them, Your Honors. So the AI algorithm will imbibe such biases which will result in violation of right to equality, Your Honors.
See, when it comes to such vices, unless and until you put inputs in that way, because when you conduct doctrinal, non-doctrinal researches also, you have a sampling to be done in place. You have a questionnaire stuff, so you prepare it in a fashion. Then you should have some composite picture ultimately. Understood? So when that composite picture is coming out, something could be deduced out of it. So more or less, it can never be said that, the data which comes out may not be believed or should be kept aside. That kind of assumption cannot be made.
Your Honors, the Council is pleading before this Honorable Court that the kind of data is being provided to us, but the source code of the data is still not clear to us. The source code of from where the data is being collected, whether it is going to be collected first hand, it is going to be primary data, secondary data, or an infringement of anyone's right, Your Honors, is still of clear vagueness, Your Honors. So the Council has concerns.
So please see what the data includes. Kindly go to paragraph number 12, page number 3, line number 1.
This data includes criminal history records such as prior criminal convictions, charges and arrests, democratic information...
For a moment. Prior criminal convictions, charges and arrests are the data that are available with us.
Yes, Your Honors. This particular data is available for the public record, Your Honors. However, the data is not limited to this. It is including this but not limited to this data. It also includes data such as socio-economic background, social media activity, digital communications, an individual's psychological evaluations and mental health history, financial records, Your Honors. It's a huge list of data.
And the social media and the online activity is what? An accused himself would make it available for the public. So he cannot have a grievance over it.
Your Honors, not all public media activities are allowed to be accessed.
See, the thing is, what do we mean by public? As you are using this term public, so again this public is abstract term. When it comes to the data which is to be made available under these circumstances which the court is entertaining, what kind of public are we talking about? And second thing, as my brother judge is also rightly pointing out, when it comes to the important parameters, they are definitely provided over there. So some kind of assumption could be made, and which is going to be decisive. Understood? Which is going to be decisive. That is what the court believes. So therefore, when it comes to such algorithmic circumstances, so do you think that the outcome which will be coming out will have to be completely believed, or still could there be some kind of mismatches which may create some troubles in the justice delivery system?
Yes, Your Honors. Your Honors, the kind of data that is being fed is to be interpreted by an AI, the source of which is unknown, Your Honors. And the Council would also like to...
And one more point, Madam Counsel, which I would like to point out here is, such kind of data are to be, or this AI stuff has to be taken as a tool. It could be a tool which will
Yes, Your Honors.
assist the judge's concern when it comes to the final opinion which is to be made.
Yes, Your Honors, it is indeed a tool, but the tool is based on scientific methods, and the data is objective and statistically organized, Your Honors. It has a huge impact on every individual's mind, let alone the honorable judge, that the scientific data is being provided to him. Your Honor, moreover, the government of Bharat Nadu has provided a law on the same thing, which even compels the judge to keep in mind the data that is being provided to him.
Now, what is the ultimate evidentiary value of an expert report? You must tell us.
Your Honor, the expert report is of mere consideration to the judge, Your Honors. But the Council would like to again emphasize...
Can you lay your hand on a specific provision of the Indian Evidence Act?
The Council pleads ignorance and humbly apologizes, Your Honors. The Council would like to proceed with the issue.
Yeah, proceed.
Your Honor, further, the Council would like to contend that Article 14, the Article 14 allows some classification, but the classification must be based on intelligible differentia, as in the case of Ramkrishna Dalmia versus Shri S.R. Tendulkar. If Your Honors may refer to the highlighted part, it says that the classification must be found on intelligible differentia, Your Honors. And in this case, however, the Council would like to plead that there is no presence of intelligible differentia, Your Honor. The data upon which the predictive AI algorithm relies isn't necessarily reflective of who is more likely to commit a crime. Rather, it is reflective of who is more policed, Your Honors. Your Honors, the more a certain group is policed, the more algorithm believes that a member of a certain community is a potential criminal, and in return leads to more policing of that group, and the loops goes on, Your Honors. So there seems to be no intelligible differentia, rather only perpetuating biases.
Any case law which validates this very point of yours? Any latest judgment which this court has delivered in the past, recent past, which just promote your argument in affirmative?
Your Honor, the council has the case of Sri Ramakrishna Dalmia along with.
Proceed, proceed.
From the non-facts, kindly come to paragraph number 10, line number 3.
Yes, Your Honors.
The results of the pilot program were generally positive. Number 1. And the query that we had raised to your colleague, that is at paragraph number 15.
Yuga Drishti has been statistically proven to be more accurate. Your Honors, the prediction is generally correct, Your Honors. Your Honors, the jurisprudence in Indian law is that it is better that 10 convicts are released than 1 innocent is found to be guilty, Your Honors.
See, Madam Counsel, when it comes to the collection of data, sampling plays a very important role. So merely on the basis of having 10 samples, you can't generalize the wholesome opinion. So the more is the, you can say, number of people who are participating, the better it would be to gather that particular data, which will definitely have some variance in the minds of people. So that point is also very much important, right, to be zeroed in on when it comes to collect such kind of data which you are talking about.
Right, Your Honors. Your Honors, the team which made the program called Yuga Drishti did include a vast number of legal experts and experts from all the fields, Your Honors. But again, that also perpetuates human biases as well, their own opinions that and the data that is being fed to the, again, the council would like to emphasize that the kind of input that is being fed into the AI algorithm would determine the kind of output it would produce. And even in the annexures, it has been contradicted and said that it has not always proven to be correct. And even in the cases the Honorable Court has decided to go with it, there's no proper reasoning or transparency that can be relied on.
That is where the safeguard in paragraph number 18 is contemplated. Now the judge will always have the final say. It is not that the algorithm itself is giving the sentence. I think that will take care of the situation.
Correct, Your Honors, but the council would like to plead that the judge does have the final say, but the AI algorithm, being a statistical scientific data, would influence the mind of a judge to a huge extent, Your Honors, and it would cause some imbalances and some lopsided views in the mind of a honorable judge as well, Your Honors.
See, the thing is, the judicial mind or the judicious mind will also have to be applied by the judges itself, as Brother Judge has rightly pointed out, that when it comes to the submission of data, which has been submitted to the Honorable Court, so it is for the court to decide as to whether that report has to be taken in affirmative, to what extent. So it's up to the court to decide, yes. So as far as possible, the data has to be gathered, has to be submitted as best as possible. So that should basically be the gesture. Right? So, and when it comes to the, as you have already made a mention of this tool, so definitely tools are going to be there. Tools are going to assist you, but tools are not going to take over you. Understood? Yeah.
Yes, Your Honors, the council also pleads in a similar direction that a human judge can in no way be replaced by an AI algorithm, Your Honors. And in fact, there is no particular need in this situation to bring out such AI algorithm, because a judge, while taking a decision, considers various factors in mind, including the circumstances that are unique to the case, Your Honors, which the AI algorithm can never predict because it does not have a mind of its own.
The need for it has been spelled out at paragraph number 16. Counsel, you need to be extremely clear about the facts.
Yes, Your Honors. The government of Bharat Nadu has claimed that due to expenses in the judicial system, increasing expenses in the judicial system, they felt the need to bring the AI here, Your Honors. But if the AI is compromising the quality of sentencing or the judgment, Your Honors, then, Your Honors, that would be of no use, because there is no use of providing fast justice if there is no correct justice, Your Honors. If it is being biased by a particular opinion of an AI or being persuaded by that, then
See, Madam Counsel, law does not go by the emotions. Right? You are just advancing your arguments in that sense that when it comes to the acceptance of rejection of such things or such, you can say, data which is made available. So it is up to the court to decide. At the same time, there has to be an authenticity into it as well. So the more the authenticity, the better it would be.
That is exactly the concern of the council, Your Honors. The data that the report that is provided to the honorable judge is a mere compilation of facts and data, Your Honors. There is no transparency as to how much weightage is to given to which criteria or what is the relevance of using that particular data in a case, Your Honors, is absolutely missing. The data that is being provided might not be sufficient. Your Honors, would the council proceed? No? Thank you, Your Honors. It was an honor arguing in front of the bench.
Well, the other side can come.
Yes. Permission granted.
It's our duty, counsel. It's our duty to hear you.
Indeed, Your Lordships. However, for the sake of brevity of the proceedings, seeks the kind consent to collectively address the bench as Your Lordships.
Please.
Grateful, Your Lordships. I will be taking up issue 2 and 4, whereas my co-counsel will be dealing with issue 1 and 3 and will be speaking for 14 minutes each, reserving 2 minutes for sir rebuttals. The council represents the respondent, the Union of Bharat Nadu, in the matter of the democratic reform projects and others versus the Union of Bharat Nadu. The council seeks permission to proceed with the arguments.
Please.
The present case deals with the constitutional validity of the use of yug drishti in predicting criminal behavior. For the sake of the same, I will make two broad submissions. Firstly, the use of an AI algorithm does not violate the right to equality as enshrined under Article 14 of the Constitution of Bharat Nadu by disproportionately affecting certain communities. And secondly, it does not violate the right to privacy of an individual as constituted to be a part of Article 21 of the Constitution.
Madam Counsel, one question is coming into the mind of the court as to whether AI could be seen as a personality, as a juristic personality. For example, we have so many other juristic creations in the world itself when it comes to organizations, company for that matter, companies law 201, if you go through. And most of the acts, they are defining persons in different ways. So can we also define this AI as a person out here, or have you come across any law which says or which amply speaks about this personality to be taken as a juristic personality?
Your Lordships.
As your issue number 2 is, does the use of an AI algorithm to predict criminal behavior violate the right to equality as guaranteed under Article 14 of the Constitution of Bharat Nadu by disproportionately affecting certain communities?
Your Lordships, my co-counsel will be dealing with this inquiry.
Okay,
However, for summarizing, for the sake of clarity, I would say that AI algorithm yug drishti can be seen as a legal amicus curiae in the court. We can construe yug drishti to be
See,
an
when
amicus
it comes to the establishment of a person as a juristic personality or as a natural personality, automatically rights and duties will come into picture. Understood?
Yes.
So can we also think in that way when it comes to AI? Suppose if it has been declared as a personality, so does it also exhibit rights and duties?
Your Lordships, the council is not aware about any legislation or any law that declares AI to be a juristic person.
Proceed.
But counsel, we are extremely concerned about the usage of a particular word that you made. It's a legal fiction. Should we allow the legal fiction to run the courts?
No, Your Lordships. It was a reference given. I do not mean that what I mean is that it is only and solely for on the discretion of the court to use it, and it complements the decision of the court and the judges, and it, as far as my knowledge, I don't think the drishti would be a Before I begin with my submissions, I would like to point out the case of Menga Gandhi versus Manila
We can skip this. We can come to the submissions later.
Indeed, Your Lordships. Firstly, I submit that Article 14, 19 and 21 form a golden triangle. That is, I would bottom of all of these three articles lays the proportionality test, rational nexus in theory, and arbitrariness. That is, in Article 14 and 21. Article 21, as also laid down in Khalak Singh versus.
Counsel, may I interrupt you for a minute?
Yes,
Please go to page number 3, line number 3 of the fact sheet. The data includes socio-economic background. Why do you require that?
Pardon me, Your Lordships.
The socio-economic background comes under the definition of data. It includes the socio-economic background. Why is that even required? For a pre-trial detention decision, you are falling upon the socio-economic background of a person?
Yes, Your Lordships. For example, if we take whether or not a person should be granted bail, a lot of factors are to be considered. Under section, I believe, 437 of the CRPC, when a bail is to be granted to a person, a lot of myriad of factors are to be considered, including whether or not a person inhibits, whether or not a person might flee the country, whether or not a person can manipulate the evidences and the witnesses. I believe all of this data would help in construing such facts. Firstly, with regard to the question of equality, the Council relies on the landmark judgment of State of West Bengal versus Anwar Ali Sarkar.
But you apprised us that the second aspect of equality would be dealt with your colleague.
No, Your Lordships. I will be dealing with second and fourth.
Please.
Yes. That the classification that is being over here is between the persons who have been previously engaged in some criminal activity and the people who have not.
The concern is about the secrecy that you are maintaining. So paragraph number 14 is directly on it. The training data are publicly available. We do not know what you are feeding as data.
I don't understand. I beg your pardon.
Now, paragraph number 14.
Yes, sir.
The training data are not publicly available.
Yes,
That
sir.
is the concern that has been raised by the petitioners. Maybe they would be satisfied if at all you could make that public. I think
Publicly available.
but the data that you are collecting is something that you have already defined, all available in the public.
I beg to differ, Your Lordships. The kind of data that is being collected is available, but the data itself of about a particular individual
What is data, by the way, out there? Within the given premises, how do you define data?
Your Lordships, I would like to make a reference to the Digital Data Protection Act that is being introduced.
Which year it came into being? Which year this act came into being?
2023, Your Lordships. February.
Does it define data?
It defines sensitive data, Your Lordships, and it defines sensitive.
At least there is a difference in between data and sensitive data.
Indeed, Your Lordships.
And personal data, private
Indeed, Your
data.
Lordships. Indeed, Your
All are
Lordships.
different, or all are having the same?
They're not.
They will
the
be
same.
taken as synonym to each other.
They're not synonymous, Your Lordships. May I proceed with submissions? Firstly, with regards to equality, the Council relies on the landmark judgment of the state of West Bengal versus Anwar Ali Sarkar, which laid down the test of reasonable classification. Now, this classification is being made, the class that is being, a new class that is being created is of the people who have been priorly involved in some criminal activity. Now, this differentiates these people from the people who have not been. So, the council submits that there exists the classification that is being made is reasonable, as was also observed in the case of Maneka Gandhi versus Union of India.
Counsel, the reference to the citation would be of no avail as long as the facts are otherwise. Paragraph number 10. Kindly go to paragraph number 10.
Yes, Your Lordships.
Please go to line number 3.
Yes, Your Lordships.
The results of the pilot program were generally positive, but the concerns were raised about potential biases and errors in the data used to train the Yuga Drishti.
Yes,
This is precisely the submission of the petitioner.
Your Lordships, my co-counsel will be dealing with that. But again, there exists a review mechanism and there exists a way of redressal. That is, amendments can be brought in by the government if there are any biases or errors found in the functioning of Yuga Drishti.
But you do not let us know who those experts are. Yes.
No, Your Lordships, the Yuga Drishti AI was developed by a range of experts who hailing
See,
from.
this could never be quoted or said at range of experts. You should have a befitting sort of answer to this thing, like there are 5 people, 6 people, because whenever the committees are also constituted by the Honorable Court, so definitely there is a presence of some certain number. Let us see, 5 members are there, 6 members are there. You can see the SEBI Board Act for that matter. SEBI Board is also there. You have Competition Commission of India. You have different boards for different quasi-judicial authorities being created. So you have specific number of people there. Plus their roles are also defined. So that way, can you define some kind of roles which were assigned to those people who were part of this stuff which you are talking about? Range of experts, because ranges again get vague. Like there could be 100 number of people, so we are not able to understand. The court is not able to understand how many of those people have contributed towards the creation of this data.
Your Lordships, the same is being mentioned in paragraph 7 of the fact sheet. Although the problem is silent upon how many experts or what is the designation of each person belonging from a different background. However, I would like to bring to your Lordship's attention to page 62, paragraph 17 of the compendium, which to the recent judgment of State of Uttarakhand versus Sudhir Buddhakoti and others. It was observed that when a classification is made on recommendation made by a body of experts constituted for the purpose, courts will have to be more wary of entering into the said arena. So, I believe this satisfies your point.
But the same question to you, counsel. What is the relevance of an expert evidence? Yes. What is the evidentiary value of it? So you are taking us to a situation where the algorithm gives a particular data and the judge is bound to follow it. Yes. If at all he doesn't want to, then he must give reasons for the disagreement.
I would like to defer your Lordships, but the judge is not bound to follow it in any way, and as my co-counsel would brief upon the same, that the AI Yuga Drishti is merely complementing the decision of the court and is in no way, the judge is in no way bound to follow the decision given by Yuga Drishti.
So in absence of amendments to Indian Evidence Act, can we sustain this kind of a change in the judicial mechanism?
I don't understand what you're saying.
See, the thing is, given the picture which is being shown to us right now, the judge is basically saying, can there be a kind of suitable cognizance of such kind of changes, and can we go honor such kind of changes, that yes, such changes are not to happen, we should acknowledge.
Indeed, your Lordships. There is, if the decision that is given by Yuga Drishti is in any way...
Or can it be said that there should always be the presence of human agency when it comes to look into such kind of matters which are being seen, being looked into by AI? Do you think that there should be a presence of a person or a human being there?
Indeed, yes, your
We should just verify all that stuff, then maybe court can take cognizance of that matter.
Yes, your Lordships. I would, with the permission of the court, the counsel seeks to proceed. wish to point out page 76, para 8 of the Compendium, where Justice Bhagwati, speaking for a five-judge bench in R.K. Garg versus Union of India, held every legislation, particularly in economic matters, is essentially empiric and based on experimentation. There may be crudities, inequalities, and even possibilities of abuse, but on that account only, it cannot be struck down as invalid. In toto, the Council, with regards to the first issue, pleads that in contrast to violating the right of equality, the introduction of Yug Drishti, that is an AI algorithm, promotes equality.
Thank you.
It was an honor argument.
Thank you. Yes,
Warm greetings to the bench. I counsel for respondent dealing with the issue first and third. If the bench don't have any pre-queries, counsel seeks permission to proceed with the first issue, that is, does the use of an AI algorithm in pre-trial detentions, bail hearings and sentencing violate the right to fair trial guaranteed under Article 21 of a Constitution of Bengaluru? For submitting the same, I will divide my submission into three different parts. First will be the discretion of the court, second will be data division making as an assistance to the court, and third will be promotion of a speedy trial in some angle and helping the Bharat Nadu in promotion of a speedy trial for that matter. When I say a presumption of a judicial discretion, it is clearly mentioned in the fact sheet that final say will be reserved with the judge. We see that judicial discretion is a very important power given to the judge for understanding the
complexity of individual cases and understanding a socio-economical background, all the cultural things, and all the things should be taken in a consideration while given the decision for the same. So if we are giving the final say to judge, we are also giving a right to that person to come before the court and argue their side against the AI, against the arguments made by the other counsels, and also we are giving equal and fair chance to them to come up in front of a court and put forward.
Concern is regarding bias.
Yes, concern is regarding bias, sir, but here we are not mandating these decisions over a judges. It is clearly given in the passage 30, it is mandated to consider it.
Paragraph number 11.
Paragraph number 11, counsel 6 ignorance. It is
Paragraph number 11.
Just to go through.
ಮತ್ತೆ ಕರೆಕ್ಟಾಗಿ ಬರ್ತಾ ಇದೆಯಾ? ಮತ್ತೆ ಅಲ್ಲಿ ಆಮೇಲೆ ರೆಕಾರ್ಡಿಂಗ್ ಅಂತ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು. ಅಲ್ಲಿ ಬಿಡ್ರಿ ಇಲ್ಲಿ, ಮತ್ತು ನಮಗೆ ಇದು ಆಮೇಲೆ ಲಾಸ್ಟಿಗೆ ಅಪ್ಲೋಡ್ ಮಾಡೋದಿದೆ, ನಾವು ಅದು ಮಾಡಲ್ಲ. ಆಗ್ತಾ ಇದೆಯಲ್ಲ?
Yes, it is passed law mandated to consider it, not to get bind of it, my lord. It is just suggestive nature. It is with some data which is provided to judge. Judge has full right of going against him and giving his own opinion with regarding to its judicial.
It is only a suggestive mechanism. Yes. And what is the secrecy all about?
The secrecy is all about the national security. As my counsel also told that it will be dealt by me. This is an AI algorithm where we are putting some kind of...
Mr. Counsel, are you only going to be concerned about national security? What about national morality, national integrity?
Again, the question can be revolved around the same national integrity and all this morality also, because when it comes to the national security as overall aspect, the AI is a data division decision making. We are going to provide some things. Source code and training data will be like, if somebody is doing A, B and C, fulfilling three of conditions, it will provide a probability of the same. And if the data will be revealed to the people...
Mr. Counsel, in the eyes of law, as we just already made a mention, that the person or the AI, unless and until it is given the status of a person in the eyes of law, how can something which is being done by it could be taken care positively? Because in the eyes of law, it is nothing. Still, the world is divided. The world is perplexed in the state of limbo. So how this court is able to understand this notion of yours?
But the law, at the second hand, the law is passed by a parliament itself to take into a consideration.
But when it comes to AI, this is to be taken as a plural entity. It is not to be taken as a singular entity. It can be defined in many ways. So which aspect of AI are you getting concerned about out here when it comes to the creation of data?
we are putting lots of data, but it's not clearly mentioned that it is a singular entity or it is a plural entity in the fact sheets. So council don't have knowledge of the same because it's not mentioned in the fact sheets for the same. And when we move forward to the data driven making decisions, we are providing the data and assisting the court. Like take an example of a calculator. We are saying that 22 first 24, it will take some time to analyze, but in a machine learning, which is self-learning machine learning with added some course data, it will make more easy and more less timely to give
The
a
appreciation of evidence, 2 plus 2 is equals to 4 logic works in the realm of appreciation of evidence.
No, it's just a drawn analogy from the side of council to address the importance of a speedy trial and giving decisions at a speedy level. Because if we go through the facts, the country Bharat Nadu is going through the cases which are pending, going through the some problems like crime rates, increasing of a crime rate.
Council, when it comes to provide speedy trial, there are some important notions to be observed while doing so, and in most of the acts you must have seen that platform. So here, when it comes to provide speedy trial, simply does not mean that you are going to cut somebody's throat who has not done any kind of heinous act. So that point should also be worth mentioning. That has to be taken care.
Indeed, and this has been argued from the side of a respondent that we are collecting data by a reasonable means. We are collecting data and then we are utilizing that data in the data division making. Again, we are giving opportunity to that person to come against the courts and robust their right to legal defense, and we are giving discretion to the judge, as we have the importance to discretion of a judge in overall criminal justice process, and we are providing all the necessary things and reasonable and fair manners with the same data division making system.
Proceed.
If councils don't have any pre-queries related to issue number 3, the issue number 3 deals with the aspect that does the use of an AI algorithm in a criminal justice process raises concerns about transparency, accountability, and for that matter due process also. When we talk about the transparency comes with some reasonable restrictions, as mentioned in the very recent judgment of State of Punjab versus Baldev Singh. It is clearly mentioned that the restrictions.
Council, paragraph number 10 of the fact sheet, line number 4. Who is accountable for the errors?
While answering this question put forth by the Honorable Bench, it is clearly mentioned in the paragraph 70s that there will be, as it is in a review mechanism, AI is in a review mechanism, and we are providing chances to give a feedback and also some reviews.
We are trying to minimize the error. You are not ruling it out. That is where the concern of the petitioners is, it lacks transparency and accountability. Whom do you hold accountable for the errors which are admitted to have taken?
For that matter only, as it is in a review mechanism, we are giving judges to power to decide what is good and what is bad. And judges' discretion will be a final say.
See, the thing is, first of all, the creation of data is important. As one of the members of your presentation stuff is basically telling us that number is not known. Number means like how many people have contributed towards compiling this data. So if that is not known, if something goes wrong, then how we are going to hold liable, and how many of those people, because people will be given different responsibilities. They will not be the same, right? So we have the concept of, for example, vicarious liability. In tort law, you must have gone through Relay versus Fletcher case. You must have gone through Union of India versus this one. Oleum gas case is also there. Bhopal gas case is also there. So you have some kind of jurisprudential aspects which have been touched on. So here, in this case, unless and until the parties are known to you with rules, it will be too difficult for the court to, you can say, take into account this responsibility structure.
As the fact sheet is silent on the numbers, but fact sheet is just mentioning that they are the legal scholars, engineers, criminal justice experts, and some experts related to AI. And the chosen by the parliament itself must be chosen by a parliament itself. So we can rely on them as they are providing good things. As I mentioned, it is a review. It is in a review stage. We are giving chances to these people also while taking a feedback.
So let us know this. You are making so much of a post about the entire algorithm and its working. and then you are telling that the judge is independent to come with his own conclusion. Are you not imposing something on that? And it is ultimately, I tell you, that it is impinging on the independence of the judiciary by imposing such a procedure, which is not even contemplated or amended by taking any amendments to the Indian Evidence Act or the CRPC.
If we see the cases and the crimes in a consideration like bail hearing, sentencing and preventive detention, all consist of some sort of a criminal background, all consist of a behavior of that person.
How can you
by
your prosecutor?
Yes.
That will be pleaded by your prosecutor by filing a statement of objection. Why do you require an algorithm for that?
Again,
you want a machine to tell us what needs to be done.
Yes.
And if the machine is telling something and I want to decide it in a different way, I need to give reasoning for that.
Yes.
You are putting it above me.
There is a
Mr. Consul, I also do agree with the brother judge is making a very, very important and genial point out here. See, the thing is, tool can assist, right? But tool cannot just decide the wholesome matter, right? Because you see, when it comes to the judicial standpoint, it takes care of the, all sort of circumstances, which are basically bothering that particular issue which has come before the court. But such cannot be done by AI or by that tool. It cannot be done. All the circumstances, for example, emotional circumstances, psychological circumstances, economic circumstances, physical circumstances, economic, they all cannot be taken care so far as AI is concerned. But such can be done by the human being who is acting as a judge in some capacity. So what is your take on this?
This AI mechanism is just giving a probability of that person to commit a crime. It's not delivering any kind of a judgment and not interfering in any kind of a judgment. It's just giving a probability, and also it consists the reasoning given by a judge can also be used to improve it as a feedback in a further cases, and the government is taking care of all these things that the AI will come as a good tool in the future as it's in a review mechanism.
Sir, what is the precedent value in a criminal justice dispensation system? The value of precedents.
The value of precedent in binding on a lower courts if it's given by the higher courts. The precedent should be considered if it is from the higher bench to the lower bench, that in deciding the similar cases or cases related to similar facts of law or a rule of law.
Is it true with regard to criminal cases also?
Yes, it is true with regard to the criminal cases.
Are you sure about the proposition that you are moving?
Yeah.
Proceed.
And while proceeding with the transparency method, as I mentioned, the AI consists of a training data and source code. So it can consist of main factors like that. If the person did this, if the person did this, and if the person did this, there are high chances of getting the probability of coming as a criminal. If this data will be made public, there can be people who can try to escape these algorithms, these training data, and they can come with the new things. Like if the ABC are the training data and source code to provide the probability, people can come with the DEF for committing a crimes, and that's why for security of a nation, morality of a nation, and securing the integrity of a nation, we are not making this data public, and we are keeping reasonable restrictions, and reasonable restrictions cannot be considered as a concern.
So that is where we are concerned. You are collecting such a huge data, and now you are saying that D, E, and F can also be hacked by somebody else. Now, how protected are the data of the citizens of this country at your hands?
The data is protected at our hand because we are not infringing their privacy, we are not making it public, we are also making sure that data is sensitive in the nature.
That's why, Mr. Counsel, the research has to be magnificently done, because before you are giving us these facts in this code, the thing is like how better your research is. So research will definitely be able to provide us that understanding, provided you have done that. And at the international, for example, platform, what kind of nuances are there, how they are being tackled by the courts outside. Accordingly, some inference could be drawn, even by you people, understood? So that is how you are able to put up all these facts in a much better and congenial manner, which could be believed.
There are some examples like e-compass by using US. Courts also validates its constitutionality by having certain concerns related to it, because they think that it is bringing
that
more.
That is fine, but authenticity, from where the authenticity is coming? For example, the data is there, somebody has to approve it. So AI itself cannot approve it, somebody, right, who is expert in that sense. And accordingly, the law frame has to also take care of it. Fine. Thank you.
It's honor to please.
Repeat. Please.
Your Honor, while my learned opponent counsel relied on the submission that data being collected is of particular people who have criminal histories already, and however, Your Honor, that cannot be held against them if they have undergone reformation, Your Honor, if they have completed their course of the punishment. So the counsel. Should the counsel proceed, Your Honor? So such evidence cannot be held against the person twice, Your Honor. He has underwent the reformative process that he was allotted to, Your Honor. And he has a complete right to know what evidence is being used against him, which in this case is not being provided.
It will be made available. You need not worry. In the course of the evidence, all these things will be made available.
Alright, Your Honor. Your Honor, my learned opponent counsel also said that the final say is with the judge. Your Honor, the counsel would like to quote that the justice might not only should be done, but also should have been seen to be done, Your Honor, which is violated here. Further, my learned opponent counsel also mentioned that the convict or the accused could defend himself against the use of AI, which includes further one more complication in this step. Your Honor, plus how can the convict challenge it if there is no transparency, if there is no availability of how the data came into being, how can it be challenged, Your Honor? Your Honor, further the speedy trial, as far as speedy trial is concerned, fair trial cannot be compromised just for a speedy trial, Your Honor. Your Honor, non-infringing privacy is misinterpreted by my learned opponent counsel. It is not related to making it public to the whole of the nation, Your Honor, but rather from individuals to the state, Your Honor. There the right to privacy is being violated, Your Honor. Thank you so much. That's it.
Granted, please.
Proceed, counsel.
Yes, with respect to the first submission that was made by the counsel for petitioners, I would say justice, as they mentioned, justice should be seen to be done here. I would like to make a mention to Article 38 and 39 of the Constitution, which says certain principles of 39A and 38 Clause A of the Constitution state to secure a social order from promotion of welfare of the people and equal justice and free legal aid. I would like to highlight that equal justice is seen to be done and also done as as already dealt with during the pleadings, that a reasonable classification is being made by
the allegation is of a bias when you make the classification. You haven't addressed just on the aspect of the bias.
I beg your pardon, Your Lordships.
The allegation that is being made is regarding the bias that creeps in when the classification is being made. That was the submission of the
Your Lordships, I would bring to the court's notice, for example, media trials or the breakfast theory. Let's say if a judge wakes up in the morning and sees some news on the news channel, obviously it is bound to make some impression in the mind of the judge. Also,
so now you are coming with an algorithm which dictates the way in which the discretion have to be exercised.
See, the prudence is already there in the mind of the judge. So when there are news which are there before the judge, so definitely he will apply his prudence.
Indeed.
And accordingly he will just go ahead with that news, right? Maybe in positive manner, in negative manner. So, but it cannot dictate the mind of the judge as to just only to see one aspect of it.
Indeed, Your Lordships, and as pleaded by the counsel earlier as well, and also mentioned in Article 2 of the Annexure 1, it only acts as a complementary in a way that helps the judge and not in a way that dictates his mindset or not in a way that makes him bound to listen to the AI algorithm.
Thank you.
Thank you.
Grateful, Your Lordships.
Thank you, participants. I request you to assemble in the backstage while the judges inform what's going on. the judges. Now I request Ms. Tilaka, Assistant Professor of Law, KLE Law College Bengaluru, to introduce the judges.
Thank you, Aditi. Good morning, all law present here. I consider it's my pleasure to introduce the distinguished panel of judges. We have Dr. Rahul Mishra, sir. Sir is a dedicated, honest, and sincere and committed to the teaching profession with a teaching experience of 14 years with a rich academic and professional background. Sir is currently serving as an Associate Professor of Law at Manipur Academy of Higher Education, Bangalore. His academic journey includes roles such as lecturer at law at Nalsar University of Law and subsequent positions at Amity Law School and Alliance School of Law. Sir has demonstrated administrative powers in various capacities, including heading the Legal Services Clinic at Manipur Law School and directing the Center for ADR Studies at Alliance School of Law. His commitment to academia is evident in his active involvement in committees and boards, contributing to the development of Alliance University and recognized for his scholarly work. Sir has received the Best Paper Award for a presentation on online education's impact on the learning process. Additionally, he has successfully guided numerous LLB and LLM dissertations on topic ranging from legislative drafting to intellectual property rights and corporate social responsibility. These are merely some of his many achievements, and we are honored to be in Sir's presence today. Warm welcome to you. We have Mr. Nitish Kege. Sir is alumni of KLE Law College Bengaluru. He has represented and won many moot court competitions for the college and a university rank holder for his batch. He has active practice of over 13 years in High Court of Karnataka, Karnataka State Administrative Tribunal, Karnataka Appellate Tribunal and other tribunals. He was engaged as panel counsel for BBMP, presently panel advocate for High Court of Karnataka, Bangalore City Corporation, etc. He regularly gives guest lectures on various subjects. A warm welcome to you, sir.
Thank you, ma'am. Judges, I request you to share a valuable feedback to the participants.
Greetings to everyone assembled in this auditorium. I think this is for the third time I was invited to be a guest out here, and I can simply tell you all, especially students, this is really a platform where you guys can learn as to how to do this mooting, because mooting will definitely be a very important aspect of your professional life. I do believe so, and accordingly these are the platforms which give you ample confidence, which also makes you do a lot of networkings also. And this institution is a wonderful institution, one of the best institutions which is available in Karnataka, right, in Bengaluru. At the same time, the proposal, if you see, this is definitely something about AI. AI is also there. So now, when it comes to the world stage, even the world is also silent. It is basically divided as to which kind of law do we need. Likewise, so far as our mission is concerned, again, we are just anticipating some kind of law to be there in place. So definitely, when it comes to such competitions, they will help us understand the nitty-gritty of AI involvement into our lives. At the same time, how we are going to look into this problem, how AI is going to support our lifestyles for that matter. Because these days, you see, I think there is hardly any person who does not have access to mobile phone. So if you have access to smartphone, then you are definitely relying on technological side to a great extent. But there are also some pitfalls on the other side, which definitely the common man does not know. For example, the use of AI or the use of online platforms, everybody does it. But when it comes to the issues concerning the abuse of it, I think the people do not have much idea about it. So that is how the problems are getting multiplied these days. And therefore, this data privacy, all these things have become buzzwords. But I think we should be thankful to the international organizations like you and all. At least some thoughts have been given to these things. And now we have the GDPR guidelines in place. Accordingly, we have the DPDP law also, which is there in place. But still, we have miles to go before we sleep, because when it comes to regulate this AI scenario, when it comes to regulate blockchain for that matter, when it comes to regulate smart paisa, smart currency, still, we do not have that regulatory regime. And frankly speaking and strictly speaking, unless we have that regulatory regime or mechanism, it is going to be hazardous for the society to not only use or to also know as to how to abuse all these things, because unless you know the other side, you are not able to understand the whole nitty-gritty. So that is something from my side, and once again I express my deepest gratitude to KLE Law College, Professor Mallikarjunaiah ji, his wonderful team members, all the students, for having given me this coveted opportunity to be a part of this quarter-final session, and definitely I wish all the best to both of the teams. Please don't worry as to whether you win or lose, but you should go with the positive memories from this competition and just do your hard work, because karmanye vatikaraste ma phaleshu kadachana ma karma farhetulu gurumate sango sangate karmani. So that should be the, you can say, the karmic stuff which you people should embrace, and accordingly you should go ahead. God bless KLE Law College. God bless you all. Namaskar.
At the outset, very happy Constitution Day for all. There are 19 paragraphs in the fact sheet. All that I request both of you and any participant is, please keep abreast of the facts of the case. I found often that the facts are misquoted or not being completely read. Now, paragraph-wise, make it a point to read that and analyze it and then make a submission. Fact forms the core of the submission that is being made, and all laws are eventually applied to the facts, and as long as there is no clarity with the fact, it doesn't take us anywhere. So my request to both of the sides is, please ensure that you are well read as far as the facts is concerned. Now, sir beautifully quoted Bhagavad Gita and said that you should have taken it in a karmic philosophy. But given a chance, I would have said the algorithm should have decided today as to who should have won and who should have the other way around. But as long as it is not the order of the day, human agencies have its own way of putting the things around. One would march further and other would not. But I am assured that we are seeing minimum 6 bright stars who would be there in the galaxy of the legal fraternity in the coming days. All the best to both the sides.
Thank you, judges, for your patience and cooperation. Participants, I hope you've had a good experience in the 6th Surana Court competition. Thank you.